Dear viewers, welcome to the session of Property Law. I, Dr. Vijeta Singh from SS Mania Law College, Jalgaon, Maharashtra. Today we are going to discuss the topic of absolute and partial restrainment. Let us start with the introduction. In this life of human, property holds a great amount of value, not only economically and physically, but also emotionally. But sometimes people need to transfer these properties to someone due to whatever reasons like gift deeds. Most of the time keep it inside the family or maybe to close one. In the Transfer of Property Act 1882, the laws regarding the transfer of property were discussed thoroughly for all. Alienation means the transferring of property. This transfer of property can be through gifts, sales and mortgages. Under Hindu law, no person of the joint Hindu family, not even the Karta, has the full power to alienate the joint family property or his own interest in the joint family property without the consent of all co-partners. In the case of separate property, a Hindu can alienate that property whether it comes under Dayabhaga school or Mitakshara school. This power is a absolute alienation, refers to the process of property owner voluntarily giving or selling the title of their property to another party. When property is considered alienable, that means the property is able to be sold or transferred to another party without restriction. This is based on the general rule of jurisprudence, alienatio rei pre safer jure accessendi. That is to say that alienation is favored by law rather than accumulation. Section 10 to 18 of the Transfer of Property Act 1882 states the rule for alienation of property. Let us see what is section 10 lays down, that where the transferee is absolutely restrained from transferring his interest in his property to another person because of condition which came along when the property was transferred to the transferee, then this condition will be made void. The transfer from the transferor to the transferee would remain valid. For example, A transfers some property to B as a gift, but with the condition that while A is alive, B must not transfer the property to any other person. This condition will be held void as it absolutely retains B from transferring his interest in the property to another person. This is commonly known as the rule against alienability. The Transfer of Property Act is based on the principle that there can be a free transfer of property and has been specifically made with regard to free transfer. If condition restraining transfer are imposed, then the free transfer would be restricted and there would be no use for the Transfer of Property Act. However, only conditions mandating absolute restriction are void. There are conditions which call for partial restraint to be observed with regard to the transfer of property. If we are to determine whether a condition is absolute or partial, the one must look at the substance of the condition and not merely the words. Therefore, restraints can be classified into two categories. Types of restraint: absolute restraints. An absolute restraint is such restraint which completely takes away the right of transferee to alienate or dispose of the property. The transferee can now no longer transfer his interest in the property to another person and he has no freedom to do what he wants with the property in his capacity as the owner of the property. Section 10 stipulates that any condition imposed on the transferee who would amount to an absolute restraint on the right of the transferee to dispose of his interest in the property shall be void. The property must be transferred to the transferee subject to the condition. Absolute restraint refers to a condition that attempts to take away either totally or substantially. The power of alienation, section 10 lays that where a property is transferred subject to condition or limitation which absolutely restrain the transferee from parting with or disposing of his interest in the property is a void condition. Restraination alienation is said to be absolute when it totally takes away the right of disposal. In the words of Lord Justice Frey, from the earliest time, the courts have always learned against any dives to render an estate inalienable. Section 10 relieves a transfer of immovable property from an absolute restraint placed on his right to deal with the property in his capacity as an owner thereof. As per section 10, a condition restraining alienation would be void. Section applies to a case where property is transferred subject to condition or limitation absolutely restraining the transferee from parting with his interest in the property. For making such a condition invalid, the restraint must be an absolute restraint. Two persons purchased securities in their own names with the money belonging to a third person, and on his instructions they disposed the securities in the name of that person and also the interest occurring on them in that person's account. The securities carried the stipulation that they were not to be transferred. In order to wipe out his liability to another person, that third person tendered the securities to his creditor by way of satisfaction to hold them as a beneficiary. It was held that from the very beginning a beneficial interest was created in favor of the person with whose monies the securities were purchased, and therefore his beneficial interest was transferable, because otherwise the whole transaction would have been hit by section 10. Section 10 of the Transfer of Property Act 1882, the restriction on the transfer of the property have been described in two folds such as absolute and partial. In the case of absolute restraint on the transfer of property, only section 10 of this act applies. The condition under this category termed as a void. Section 10 of the Transfer of Property Act again talks about how there would be no restriction on the part of the transferee so that he could transfer his vested interest in the property. One of the famous case of the section 10 of the Transfer of Property Act is a Rosser versus Rosser in year 1884, which held that absolute conditions void. Restriction imposed with respect to time. When any condition is imposed upon transferee who directs him or absolutely restricts him to sell the property for a particular period of time, then such condition or restriction would be treated as a void. For example, if Virat sells his house to Rahul with a condition that he should not sell it for 10 years, then such condition would be treated as a void. But in any such condition, if imposed by transferor in terms of transfer upon transferee, and it is for the benefit of the transferor and for short period of a time, then such condition or restriction would be treated as a valid. Restraint imposed with respect to consideration. When transferor has imposed a condition upon transferee that he should sell it only for a fixed price specified by him, or directs him that the property should be sold only at market price, and out of the sale proceeds something should be paid to a specific person or for a specific purpose, then such conditions would act as a restraint on the transfer of property and would be void. Such conditions cannot be imposed by transferor upon transferee who absolutely restrains him from disposing or parting of his interest in the property. For example, if Mahi sells his house to Rohit for rupees 20,000 and imposes a condition that if in future Rohit wants to sell his house, then he can sell it only for the rupees 15,000. Condition will be treated as a void as Rohit is at liberty to sell the house for any consideration. Restraint imposed with respect to the person. When there is any restriction which is imposed by the transferor which directs the transferee that he can only sell it after obtaining the prior approval from any specific person, then such restriction will be treated as a clause on property and such restriction is a void. But if condition that he can only transfer it to a specific person can be either partial or restrained. For example, if A sells his property to B with a condition that if in future B wants to sell, he would only sell it to daughter A. Such condition would be treated as a void. Next, restraint imposed with respect to purpose. If any property which is transferred by the transferor which directs the transferee that if in future he wants to sell it, then he may sell it only for a specific purpose, such restraint would act as absolute restraint on the power of transferee to transfer his interest as per his convenience and will. Exception to section 10, whenever any property is transferred which absolutely restrain transferee from disposing of his interest, then such restraint would be considered as void. However, there are certain exceptions to rule of restraint on alienation. Exceptions are in the favor of lesser and another in the favor of married women. Lease. A condition in the lease deed, lesser can impose a condition, take leasee shall not sublease it. A condition imposed in the lease deed, that lease will have to surrender the property in the event that lesser needs to sell the property will be considered to be valid condition. Thus, any condition restraining leasee from alienating leasehold property is not invalid. Next, married women. Section 10 provides second exception in relation to married woman who is non-Hindu, Mohammedan or Buddhist. It provides that property may be transferred to or for the benefit of a woman not being Hindu, Mohammedan or Buddhist. In such cases, transferor can impose a condition which restricts the right to alienate the property further and such condition would not be considered as a void. In the case of Rosser versus Rosser, A made a gift of a house to B and gave a condition that if B decides to sell the house during the lifetime of A's wife, she should have the option of purchasing gift for rupees 10,000 while the market value of the house was set as rupees 10 lakh. This condition was held to be an absolute restraint and was declared void. In case of Kanamal versus Rajeshwari, a life estate was to be created in favor of M, but the transferor gave an absolute restriction along with the property transfer to M, whilst divesting himself of all his interest in the property. This restraint was held to be void as there was an absolute transfer. In Muhammad Raza versus Abbas Bandi Bibi, a condition imposing restriction for a particular time or transfer to a specific person has been held to be void. Partial restraints. A partial restraint is a condition which partially takes away the right of the transferee to dispose of his interest in the property. Here the right is not taken away substantially. Section 10 does not explicitly talk about partial restraints. A condition imposing partial restriction is valid. Section 10 has only provided for absolute restraints. it is silent about the partial restraints, where the restraint does not take away the power of alienation absolutely, but only restrict it to certain extent. It is a partial restraint. Partial restraint is valid and enforceable in the words of Sir George Jessel. The test of whether the condition takes away the whole power of alienation substantially. It is a question of substance and not of the mere form you may restrict. Alienation in many ways you may restrict by prohibiting to a particular class of individual, or you may restrict alienation by restricting it to a particular time. A total restraint on the right of alienation is void, but a partial restraint would be valid and binding. This rule is based on the sound public policy of a free circulation. A restriction for a particular time or to a particular or a specific person has been held to be absolute restriction. A compromise by way of settlement of family disputes has been held to be valid in the Mata Prasad versus Nageshwar Sahai, although it involves an agreement in restraint of alienation. In this case, dispute was as to succession between a widow and a nephew. Compromise was done on the term that the widow was to retain possession for the life, while the title of the nephew was admitted with the condition that he will not alienate the property during the widow's lifetime. The Privy Council held that the compromise was valid and prudent in the circumstances of the case. Next, in the Gayasiram versus Sahabuddin, the sale deed contained a clause that the transferee would not transfer the property to any person either by way of sale, gift or even mortgage except the transfer of his heirs. The court held that this condition is void and therefore invalid. In Manohar Shivram Swami versus Mahadev Gurling Swami, A and B were the first cousin. A made a will of his property in favor of B. On A's death, B acquired the title of the property and sold it to C, who was also the brother of A. The sale deed contained a condition that if C wanted to sell the property, he would sell it to the seller's Jangam family and not to anybody else. The court held that the condition incorporated in the sale deed absolutely restrained C from parting with his interest in the property and therefore a void. The court upheld the validity of sale affected by C. This decision of a Bombay High Court come as a surprise, as the condition here in fact was not to sell out the family, which in a number of cases has been held to be a partial restraint and binding on the parties. In Mata Prasad versus Nageshwar Sahai, there was a dispute regarding succession between nephew and a widow. A compromise was formed that the widow had possession of the property while the title of the same was given to the nephew, with the condition that he was restricted from alienating the property during the widow's lifetime. It was held that the compromise and the condition were valid and prudent in the present case. Section 10, 11 and 12 contains certain conditions under which restraining of alienation of the property by transferee are void. It also has exceptions where these conditions may be valid. Primarily under section 10, condition of restraint can be classified into two categories, absolute and partial. Whether a condition is absolute or partial is determined by the substances of that condition, not merely the words. Condition restraining enjoyment. Section 11 of Transfer of Property Act lays down that if there is a transfer of an absolute interest, then no condition can be imposed as to how the interest would be utilized. In simple word, if an absolute transfer is made, then transferor has no right to dictate as to how to use or enjoy the property. Example, if B transfer a land to A with a condition that he would only be showing rice and nothing else, Section 11 of a Transfer of Property Act would not allow such condition, and A is free to sow anything which he wants. But in Section 11 of Transfer of Property Act lays down an exception. If in transfer a part of property is transferred, then restriction as to enjoyment can be imposed if it is for the benefit or enjoyment of other part of the same property. Example, if a house has been sold with 4 independent floors, each belonging to different individuals, in such a case, restriction can be imposed upon the owner of the respective floors so that they don't create absolute to access the use of easements for enjoying their own floors. Let us see the difference between Section 10 and 11. Section 10 specifies that in a transfer with condition that absolutely restrains the alienation of the property by the transferee, the condition will be deemed to be void. Section 11 specifies that in a transfer where absolute right in the property have also been alienated to the transferee and where a condition is imposed that the transferee cannot, in spite of having the absolute right in the property, do an act for his enjoyment of the property, such condition will be deemed to be void. Thus, the difference in these sections are that in Section 10 the condition is deemed void due to absolute restrainment, and in Section 11 the condition is deemed void due to the transfer being of absolute nature. So, let us come to the conclusions. Section 10 of the Transfer of Property Act 1882 talks about the alienation of the transfer of property by an absolute restraining condition. This section is a common case often observed in the Indian legal consultancy services. Section 10 of the Transfer of Property Act 1882 talks about the same. This act has always been up for the protection of the free transfer of the property in the country. Thank you very much.